Okay, as people are continuing to join, I'm just going to get us started with a few brief opening remarks. My name is Claire Ladd, and I am the Programs and Services Manager at the Massachusetts Nonprofit Network, MNN. Thank you for joining us today for this webinar. Just a few housekeeping items before we dig in. The recording and the slides from today's program will be emailed to you following the webinar, so please keep an eye on your email for that. If you have any technical difficulties during the webinar, feel free to reach out via the Zoom chat. And if you have any questions for the presenter, you can submit those via the Q&A function or the chat at any time. We'll have plenty of time for questions. I also want to give a little background about us here at MNN. Our three goals are to strengthen the nonprofit sector through advocacy, public awareness, and capacity building. And we offer these regular webinars in partnership with our affiliate members as part of these capacity building efforts. So please stay tuned for future webinar topics and let us know if there's any topics you'd like to see. Our efforts are made possible by our more than 600 member organizations. So to those of you who are members, thank you for your partnership. And if you have not yet joined the network, but would like to take advantage of the different opportunities and cost savings, you can visit massnonprofitnet.org/join. Today's webinar is titled Common Employer Pitfalls and How to Avoid Them, and the presenter is Elizabeth Kahn, employment law attorney with the law firm of Elizabeth S. Reinhardt Associates, LLC. So I will hand it over to Liz to get started.
Thank you, Claire, and thank you to the Massachusetts Nonprofit Network for giving me this opportunity to present today. And hello, everyone. Good afternoon to all of you. Thank you for taking the time to attend today's presentation on common employer pitfalls and how to avoid them. My name is Elizabeth Kahn, and I'm an attorney with the law offices of Elizabeth Reinhardt and Associates. A little background on Elizabeth Reinhardt and Associates. Liz Reinhardt began her career as an Assistant Attorney General in the Massachusetts Division of Charities. She opened her own practice in Concord, Massachusetts in 2000. We are now a team of 7 attorneys working exclusively with clients in the nonprofit sector. And I am proud to say that this past year, Liz Reinhardt was recognized by Lawyers Weekly as one of the top women of the law in Massachusetts. It is quite an honor. What can Elizabeth Reinhardt and Associates do for your nonprofit? We work with all types of 501c nonprofit organizations, including but not limited to nonprofit corporations, charitable trusts, and religious organizations. We act as in-house counsel for many of our clients. We advise on legal matters, including board governance, all aspects of the nonprofit life cycle, from formations to dissolutions, employment matters, corporate law, contracts, and board training. As I said earlier, my name is Elizabeth Kahn. My background is in labor and employment law. I worked for the Commonwealth of Massachusetts in the Human Resources Division for several years before going into private practice. I joined Elizabeth Reinhardt and Associates over 3 years ago. Now I work with nonprofit executives and boards on employment and human resource related matters on a daily basis. And as you will tell from this presentation, I'm a big employment law nerd, and I really love working with our nonprofit clients. Before we get started, I just want to let you know that this presentation is for educational purpose only. It is not legal advice. And without further ado, I would like to present common employer pitfalls and how to avoid them. Why is employment law important to nonprofits? According to the National Council of Nonprofits, nonprofits in America employ more than 10% of the private workforce, which is more jobs than in manufacturing, construction, or finance. We find that in the nonprofit world, often nonprofits are so mission-driven that they do not pay adequate attention to personnel matters until there is an issue. And by then, it is too late. A complaint has been made to the Attorney General's office, or a lawsuit has been filed. We have heard that over 80% of legal claims against nonprofits are employment-related matters: discrimination, sexual harassment, or wrongful termination claims. In today's presentation, I will cover common nonprofit employer pitfalls, including final wages, severance payments without releases, paid family medical leave or PFML, classification issues, personnel records, and most importantly, suggestions on how to avoid them. Another disclaimer: I will be going over the basics since we only have an hour. Each one of these topics could be a whole presentation by itself. And finally, I welcome your questions. You can type them in the comment section. However, for today's presentation, please remember that I cannot give you specific legal advice. Please try to keep your questions as general as possible. Employer pitfall number 1, and my biggest pet peeve: final wages. Massachusetts wage and hour laws control the payment of wages. Wage and hour laws dictate how employers pay their employees in the Commonwealth. It sets out the frequency of payments, as well as how to pay employees their final wages. If an employee resigns, all wages are due on their next regular payday. This includes payment for all accrued unused vacation time. Please note that Massachusetts considers accrued unused vacation to be wages. If an employee is terminated, all wages are due on their last day of employment. Again, this includes payment for all accrued unused vacation time. If you remember nothing else from today's presentation, please remember this slide. Wages that are direct deposited must hit the employee's bank account by midnight on the day it is owed. So for employees who resign, this means by midnight on their next regular payday. For terminated employees, this means by midnight of their last day of employment. I cannot stress this enough. If necessary, because sometimes there are delays with payroll companies, you may pay by check or as a last resort, cash. Please ensure that the proper withholdings are taken from the final payment. If you pay in cash, please remember to get a signed receipt or acknowledgement to show that the payment was made appropriately. And finally, double check your math. If you shortchange your employee, you will be liable under Massachusetts wage and hour laws. Please do not fire someone on the spot. If an employee does something egregious, immediately place them on administrative leave with pay. This gives you a chance to calm things down and allows you to make a thoughtful decision. Conduct an investigation, gather the evidence, talk to witnesses, and document. Consult legal counsel. Decide on a course of action. It could be no discipline, a verbal or written warning, a suspension, or termination. If you are terminating, take the time to make the necessary arrangements to ensure that the last wage payments and any accrued unused vacation time can be properly paid out. Then, when your ducks are in a row, proceed with the termination process. It is so important to do this correctly, as violations of wage and hour laws are not typically covered by insurance. As an employer, you are 100% liable for any mistakes. Treble damages. This means that the court will take the amount of the unpaid wages, including vacation, and multiply that figure by 3. You are also liable for attorney's fees, and the courts have no discretion to reduce the damages. I can't tell you how many times I've seen nonprofits make these costly mistakes. In addition, the Massachusetts Attorney General's office may conduct their own investigation into complaints of wage and hour law violations. The Massachusetts Attorney General can impose additional fines and penalties, including criminal penalties in extreme cases. With that said, the Massachusetts Attorney General's office has a hotline which is staffed by attorneys from their Fair Labor Division. They are very nice and very helpful. I realize that employers may be reluctant to call, but you can talk to them anonymously. They are there to serve you and would prefer you check with them instead of making a mistake or doing something illegal. This is a hotline to ask questions about wage and hour laws, not only for complaints. They also have a website that has a lot of information and resources, not only for employees, but for employers as well. Speaking of terminations, severance payments without releases. Scenario number 1, the employer decides to let an employee go. It could be for a layoff or a termination. Maybe there was a performance issue. The employee wasn't a bad person, they were just not the right fit for this role. The employer feels badly and wants to soften the blow a little, so they give the employee 2 weeks extra pay from their last paycheck. It's a severance payment of sorts. The employee accepts the money, then consults with an attorney and files a discrimination claim or a wrongful lawsuit against the employer. Even if the employer did nothing wrong, they will have to spend time and money defending their actions in court. Not to mention the damage to their reputation and employee morale, because the ex-employee is all over social media bashing the organization. What could the employer have done differently? And how do you protect against this type of situation? Scenario number 2, the same set of facts. The employer lays off an employee. The employer wants to give the employee some extra money, but they also want to protect their organization from a lawsuit and from reputational damage down the road. How do they do that? The answer is a separation agreement with releases. It's the same scenario as before, but this time the employer offers the employee a severance payment in exchange for the employee signing a separation agreement with releases. This means that in order for the employee to get the extra payment, they need to sign the agreement. The agreement can include terms about unemployment, references, confidentiality, return of property, and most importantly, the agreement says the employee will not sue the employer in the future. In this situation, the employee takes the agreement home to think about it and consults with an attorney. They sign the agreement. The employer pays the extra 2 weeks' pay. By signing the agreement and accepting the money, the employee releases any potential legal claims against the employer. This does not mean that the employer did anything wrong or that the employee actually had any legal claims. It is insurance for the organization against future lawsuits. Now, the employer and the employee have a contract which is enforceable in court. So later on, if the employee does try to sue the employer can enforce the agreement in court and is protected from the employee's lawsuit. A separation agreement with releases acts as insurance against future lawsuits by disgruntled employees. The employer gets protection against future lawsuits, confidentiality breaches, and loss of property. The employee gets additional money, neutral references, and assurances that the employer won't oppose their unemployment claim. And they both get mutual cooperation, protection against reputational damage, and most importantly, no admission of guilt or wrongdoing. Any questions or comments?
There's a question in the chat from Maria. What about severance policies that apply to all employees with parameters, like employees who leave through resignation or layoff receive 1 week pay per year worked?
I would suggest adding to the policy that you have to sign a release statement, releasing any potential claims before you can get the severance payment. That's what we typically advise our clients if you have that as a policy. Thank you for that question, Maria. Employer pitfall number 3, paid family medical leave or PFML. Massachusetts paid family medical leave grants eligible employees paid job protected leave for qualifying events, such as to care for the employee's own serious medical condition or the serious medical condition of a close family member, and this also includes family bonding leave. Now, please note that almost all employers are covered by PFML regardless of size. The exception to this is for religious organizations and employers with better private leave benefits. I just want to say that employment laws are the minimum requirements by law. Employers can always be more generous. The employee's job is protected during the leave and up to 6 months after they have returned to their duties. By law, there is an automatic presumption of retaliation if there is any negative change to the employee's status, such as a demotion, a change to their employment benefits, a change to their pay, or any other terms or conditions of their employment. And that would apply during their leave or during the 6-month period after they return to work. This presumption can be rebutted. So how? The employer can rebut the presumption of retaliation by showing through clear and convincing evidence that the employer's actions was not retaliation against the employee for taking the leave, and the employer had sufficient reason, separate from the leave, for taking the action, and they would have taken the same action at that time, regardless of the employee using the leave. How do you do this? Documentation. It is particularly important if the employee is having a performance issue. We often have employers complain about an employee for poor performance, but they have no documentation to back up their claim. Please note that this protection and presumption of retaliation shall apply regardless of whether the employee has actually applied for PFML benefits. You could have a situation where the employee has a mental health issue and does not follow through on the necessary paperwork to apply for PFML due to their condition. If the employer has reason to believe that the employee would most likely qualify for paid family medical leave, the job protection applies. Now, I should say that the PFML is a relatively new law. It came into effect in 2021, and we are only just beginning to see cases come through the judicial process, with the first case being decided by the SJC last fall. As these cases make their way through the court system, we do expect to see some changes to the program, as well as to receive guidance from the courts. But for now, this is the law in the Commonwealth. What to do if an employee wants to take PFML. First, talk with your employee and get HR involved. Work out a plan for their leave. Keep communicating. Do not retaliate and return them to the same or similar job. Employees should give their employer at least 30 days notice before they take their leave if possible. In cases where that is not possible, they should let the employer know as soon as possible. And finally, employers must keep the employee's position open during their absence. Violations of Massachusetts paid family medical leave. The law allows aggrieved employees to bring a lawsuit in Superior Court for a jury trial. It has a 3-year statute of limitations, which means that the employee can file a lawsuit up to 3 years after the PFML leave. If the employer is found guilty, the court may order injunctions, reinstatement with full back pay and benefits. All damages are trebled, that means times 3, plus interest. And the employee's attorney gets their fees and any reasonable costs. For more information about the Massachusetts Paid Family Medical Leave, you can go to their website. It has a lot of information and resources about PFML for both employees and employers. Any questions or comments?
Looks like there's a question in the chat. Do you have any recommendations for opt-in PFML for religious organizations? We are legally classified as a church.
So for a religious organization, if you're not included in the unemployment requirements, then you also may have an exemption from the PFML. And that is something that you can go to the PFML website, and they do have more information there about who is qualified and who is exempted from the law. Depending on what kind of religious organization you are and what paperwork you need to file, you may be exempted from that.
And there's a question. Yes, and the question, what if due to funding cuts, the position of the employee on PFML needs to be cut?
So in a situation like that, where you can show that there was a legitimate business reason for terminating the employment that has nothing to do with the leave, that goes to the presumption. It's a rebuttable presumption, and particularly in a situation where you have lost the grant money due to the circumstances right now, I think that you could rebut that presumption if the employee were to bring a lawsuit. Also, if you're laying off other employees and you can show that it wasn't just for this employee on their leave, but a whole class of employees across the organization, that would again go to showing that it wasn't retaliation for taking the leave.
Follow-up question about the church from Sheer says, to clarify, what if I, as the executive director, want to offer PFML, but we do not legally have to offer it because we are a church? What options do we have to offer it proactively?
You always can be more generous. You can work with, well, you could sign up and opt into the system through the state. So you would contact the Department of Paid Medical Leave. There's a process for registering with them and contributing to the fund. Or in the alternative, you could always have a private health insurance program, and they often have benefits that are either similar to or greater than the Massachusetts Paid Family Medical Leave program. Okay, we will move on to the next employee pitfall, number 4. Independent contractor misclassification. Who qualifies as an independent contractor in Massachusetts? Under Mass law, an independent contractor is someone who meets 3 requirements: freedom of control, outside service, and independent business. There is a federal standard for independent contractors as well, but it's based on common law and is much less strict than Massachusetts law. If you are a nonprofit in Massachusetts and the work is being performed in Massachusetts, you must follow the Massachusetts law for employees classification. So this slide is about Massachusetts law and not the federal standards. Prong 1, freedom of control. This means that the independent contractor is free from employers' direction and control. The contractor's activities and duties should actually be carried out with minimal instruction. For example, if you are a nonprofit providing mental health services and you hire an IT consultant to manage your technology, the IT person decides what is the best way to approach a technological problem. They decide on when they will perform their duties. If they want to start coding at 3 o'clock in the morning, that is their discretion. The employer cannot tell them how to do the job or what to do. Prong 2, provide outside services, meaning the work being performed is substantially different from the employer's usual business. Back to our example. If you are a nonprofit providing mental health services and you hire an IT consultant to manage your technology, the IT person is providing a service that is different, or in other words, outside the organization's usual course of business. Prong 3, independent business, meaning that the independent contractor has their own business providing the service to other businesses as well as to the employer. For example, if you are a nonprofit providing mental health services and you hire an IT consultant to manage your technology, the IT person has other clients in addition to your nonprofit. Under Mass law, an independent contractor is someone who meets all 3 requirements. If one prong is missing, then they are an employee. So back to our example of the nonprofit providing mental health services. If you hire an IT consultant to manage your technology, but this time the IT person has no other clients, they only are working for your nonprofit, they would be an employee, even if they decided how and when they would do the work. And it was different from the services provided by the other employees. And please note that it does not matter if they only work a few hours a week. If you do not have all 3 prongs, they are an employee. Violations of the law. The Attorney General is authorized to impose substantial civil and criminal penalties to businesses and individuals, including corporate officers and managers with authority over the employee. Now, the statute is intended to protect employees from unscrupulous employers who are using independent contractors as a way to shirk their responsibilities. For example, they want to avoid giving employment benefits, workers' compensation, sick leave, and unemployment. Any questions or comments?
Question in the chat from Cricket. Regarding contractors, what if you hire someone to give a seminar? They don't have a business, but they are skilled in whatever they are teaching. Do they have to be treated as an employee?
I think it really depends on what the nature of your business is. If you are in the business of educating people by doing seminars on a regular basis, then I would think that they would be an employee. If you are a religious organization and you want somebody to come in to give a talk about an educational program, then arguably they're not an employee. But again, it goes to the totality of the circumstances. If you are directing them what they're going to be teaching, how they're going to be teaching, and when they're going to be teaching, the argument could be made that they're an employee. So it's very case specific.
Another question from Susie. For independent contractors, how is a plumbing company, for example, different from a landscaper if the organization doesn't declare a plumber as an independent contractor, but does so for their snowplow company?
So in that situation, again, it would depend a lot on what the nonprofit does, but I think it's a much easier argument to be made because most likely you're not a nonprofit that does plumbing services. You could be, but most likely not. And they would most likely have the authority to do their own work. They know what they would diagnose the problem. They would bring their own tools. They most likely have their own van. I mean, again, it goes to the totality of the circumstances. I think where it's a professional service, in a case of a plumber, they most likely have their own business and have lots of clients. But it depends again on what it is that your nonprofit is doing. I could see if you're a nonprofit that does housing for homeless people, you may want to have a plumber on your staff to take care of any kind of plumbing in your various housing units. So it really depends a lot on the circumstances, what your job in the nonprofit organization is, and who controls it, how they do the work, what discretion they have, when they do the work. In Massachusetts, there is a definite inclination for an employee. And if you don't have all three prongs, then the person should be an employee.
Getting a couple more questions on this. So clearly this is a big topic
Sure.
for people.
Yeah. No, go
Question
ahead.
in the Q&A from Laurel, what about a substitute teacher who also substitutes elsewhere and is seldom called?
I'm assuming the nonprofit is a school, and if you're in the education business and the person is working as a teacher educating, I would say they're most likely an employee and less likely to be a independent contractor.
A question in the chat from Maria. How much does this apply to business transactions? Is there a difference between someone whose business is a sole proprietorship versus an LLC versus a type of corporation?
Again, it depends on the totality of the circumstances. You could have someone who has an LLC, but yet they still are only working for one employer and only doing the work for that one employer. So in the case of the IT professional, they could have their own independent business, but only have that nonprofit as their only client. It makes it much harder to argue that they're an independent contractor under those circumstances.
And we had a follow-up from Cricket. I just want to make sure I'm understanding. If you hire someone to do a task, but they do not have a business to do this, are they considered an employee?
It depends. I'm sorry to keep saying this. As an attorney, this is what we always fall back on, but it really depends on what your business is, what your organization does, and what the job is. These are the three factors that are required in Massachusetts. So if you have somebody who only comes in on a very, very part-time basis, but they meet all three prongs, they are still an employee. If they're offering a service that they're only offering to your organization, more likely than not, they are an employee.
And a similar follow-up from Susie. Is there any threshold about how big the contractor is? One guy who owns a snowplow business versus a large landscaping company, for example.
No, I don't think so. I think in the snowplow business, you probably have a better argument that they are an independent contractor, because presumably they have more than one business that they provide the service to. However, back to my example of the nonprofit who has housing, it's possible that you have somebody on staff who does snowplow removal for you because of your properties. So it's an analysis that you really have to look at the facts and circumstances and what the details are to make that determination.
Great. Myra's asking to see the three prongs visual, but if you want to move forward, I do want to note we will be sending this out to everyone. So if you don't get this down right now, we'll be sharing this afterwards.
Sure. But there it is. It is very strict. I agree. I understand the frustration, and we hear this a lot from our clients, but this is the rules in Massachusetts. This is what we have to abide by.
Yes, Cricket asks, I have multiple clients that utilize contractors. Do you suggest they get legal advice on each person they hire?
Well, that's in my best interest as an attorney to say yes to that question. Again, it depends on the circumstances. I mean, if we hire someone to paint our house or we paint our offices, more likely than not, they're an independent contractor and you really don't need to do that analysis. But if you hire someone in-house to be your accountant, maybe. It's not unheard of to have a bookkeeper be an employee, but there are also bookkeeping services where they are an independent contractor. And again, it comes to the very specific analysis of what the job is, who's doing it, what the facts and circumstances are around that arrangement. So I understand it's frustrating that I can't be more specific, but it really is a case-by-case analysis.
Wendy asks, if the IT specialist was remote and operating in another state working for a mass organization, would that cause a problem for the mass org?
So in remote work situations, the law that applies is the law of the state. So it would be very dependent on which state they were living in and working in. Different states have different rules, and this applies not only to independent contractor laws, but to all laws, all employment laws. So if you have an employee working in New York or California, their laws are very pro-employee. If you have an employee working in another state, largely in the South, the employee's rights there are not as strong as they are in Massachusetts. So again, it's very case specific. Some states have adopted the federal rules, which are much more lenient. There are more questions. It's about 10 questions that you have to ask, but no one section is more important than the other. So unfortunately, I have to say it really depends.
Great. The last comment in here from Maria, if a landscaping company is a corporation with 50 employees, then I don't think you have employee misclassification concerns.
I would agree with that. Yeah, I would agree with that.
Yeah, she mentions, on the other hand, the gig platforms are able to create huge loopholes and treat people as contractors in violation of what I feel is the spirit of these workers' rights laws, which, yes.
Yeah. Yep, agreed. All right, moving on. Employer pitfall number 5, personnel records. Another question we get asked a lot on a regular basis is what documents belong in a personnel file. Some documents for a personnel file include the resume and application, performance reviews, job descriptions, payroll-related documents, agreements and receipts, disciplinary action, and promotions. Some documents that should be kept separate in their own secure confidential file include medical information, such as reasonable accommodation requests under the ADA, I-9s, and due to the current immigration situation, we recommend that employers do an audit on your employees' I-9s if you haven't already done so. Please make sure that they are in the proper order and that they're up to date. Also kept in a confidential file if you do a background check, any workplace investigation records, and wage or garnishments or child support records. And please note that this is only a partial listing of the types of documents that an employer may have for an employee. In Massachusetts, an employer must notify an employee within 10 days of placing any information in the employee's personnel record that could negatively affect an employee's employment. And a negative report is anything that could negatively affect an employee's promotion, transfer, compensation, or could result in disciplinary action. We recommend that employers write A copy of this document will be placed in your personnel file on employment-related documents to make sure that you are complying with this law. You give a copy of the document to the employee, and you give a second copy in the employee's personnel file. If the employee objects to a document in their file, you can come to an agreement to change or remove the document. Or, if you cannot agree, the employee may write a letter explaining their side to be kept with the personnel file. The letter doesn't change anything, but it gives the employee an opportunity to have their side represented in the personnel file. Another issue that we sometimes see is if an employee refuses to sign for a document. What we recommend is that if you are delivering bad news to an employee, it is helpful to have a witness present. If the employee refuses to sign an acknowledgement or their negative performance review, for example, we recommend just writing on the document, employee refused to sign. Then have both the manager and the witness sign and date the document. Finally, if you receive a written request from an employee to see or have a copy of their personnel file, you must comply within 5 business days of the request. Violations can result in fines from $500 to $2,500. We recommend that you review the documents in the personnel file before you give them to the employee, just to make sure that you have the correct documents in the file. Any questions or comments?
Yes, we'll start with questions on this. We also had a follow-up question about the contractors, but first, a question from Abby about this. Do personnel files all need to be physical? What about electronic documents that are submitted electronically?
That's fine, as long as they're kept in a confidential, secure file. I know that the laws haven't really kept up with the technology, and a lot of employers have switched over to electronic copies.
If there's any more questions about that. What about termination documentation? Claudia asks.
Those should also be in a personnel file. If there was an investigation leading up to the termination, that could be in a separate confidential file, but the actual termination notice, and if there's any kind of other documentation, we recommend we use a checklist when we have a termination, whether it's for cause or not for cause, and we have the employee sign that document. That would also go into the personnel file to show that they received their final payment, that whatever their COBRA information was, any kind of return of property, that they've gone over the confidentiality agreement requirements, that type of thing, that would also go in a personnel file.
Some more questions coming in. Zachary asks, how do you advise an I-9 audit be conducted?
So first and foremost, the I-9s should typically be kept separate from every other document, and they should be kept in a secure location. They are highly confidential. What we recommend doing, a lot of employers might actually have them physically in a binder, or if you have them digitally, it should be in a separate file. And I would recommend that you have somebody, and if you have an HR person or the executive director, go through the file and make sure that the information is accurate, that all of the employees have put in with the I-9 information, and that if there's anybody who has a work visa or any other kind of work documentation, that it hasn't expired. Right now, with all of the things that are going on with immigration, that's a pretty big concern, and you just want to make sure that if you do get audited, everything is appropriately taken care of. You don't want a crisis.
Claudia, follow up on that termination question. Should reasons for termination be included in the document?
It depends. One of the concerns, and the reason why I say it depends, is if you are terminating for cause, I think that less is more. I have seen termination letters that have a lot of details in them. And what that does is it gives fodder to a good employment lawyer to come after the organization. So I think there's a balance between accurately representing why there was a termination, but not giving all the details because you're setting yourself up for a lawsuit down the road. If you have a situation where, particularly if you have a kind of a nasty situation where there could be a lawsuit, I would recommend consulting with legal counsel before you make the decision to terminate. And part of the discussion with the attorney would be what should and should not be in a termination letter.
And then regarding the electronic files, Sheer asks, does it matter where the files are stored, e.g. Google Drive, Dropbox, etc.?
It needs to be a secure, if it's password protected, that would be best. Personnel documents are confidential, and you need to make sure that they're not something that anyone could get access to. Obviously, we have to be worried about hacking or any kind of cyber attack. So I would say talk to your IT professional and make sure that wherever those documents are, that they are under the securest level of storage possible on your system.
A couple more questions about the I-9s. Kristen asks, do you need new I-9 backup documentation if it is for a current employee, but it has expired?
Yes, definitely.
And Zachary asks, is it okay if the I-9 form itself has expired since the employee's hire? Top right corner says expires X date.
No, I don't think that matters as long as the information hasn't expired. So if somebody has a work visa, you want to make sure that that hasn't expired, that their authorization to work in the United States has not expired.
I mean, we can open it up to any questions. We had one more question about the independent contractors. If you hire someone remote and it's determined they are an employee and not an independent contractor, do you then need to register your business in that state?
Yes. As an employer, you have to be registered as an employer. Again, it depends on the state's rules as far as whether or not you need to register as an employer, as a nonprofit or a business in that state. So Claire, I'm looking at the time and I have my suggestions. So why don't we hold on any more questions or comments? And I just want to get to my last slide, if that's okay.
Of course, yes.
Okay. So how to avoid the common employer pitfalls. These are our recommendations. Awareness of the laws. Attending sessions like this one. Keeping up to date on relevant employment laws. There are a lot of good resources online, such as on the Massachusetts Nonprofit Network website and mass.gov. Sign up for newsletters on employment laws and human resource trends. Honest performance evaluations. Please address performance issues in real time. Check in with your employees regularly. Don't wait to discuss a problem. And please don't give good performance reviews if the employee is not doing a good job. I know people don't like giving bad news and they don't want to be confrontational, but the worst thing you can do is give a poor performer a glowing report. And make sure you do annual performance reviews for all of your employees, including the executive directors and CEOs. Documentation. Please get signed acknowledgments from employees for employment policies or agreements. It's the best way to stop an employee from arguing that they didn't know about the policy. Also, have clear policies and procedures that employees are aware of. Follow them. It is not helpful to have a great policy that nobody follows. Have a handbook for employees to look up policies for themselves. Handbooks should be up to date. It is not helpful if it's 10 years old. A lot has changed in recent years, and so should your policies. And please have a signed and dated receipt showing that the employee received a copy of the handbook. Train your employees and managers on your policies, as well as on your expectations for how you want the job to be done. You cannot assume that your employee knows what to do if you have not been clear with them about the process. Again, have some type of proof of the employee's training, a signed in-person attendance sheet, or if it's online training, a certificate of completion. Training should happen at least annually or on a regular basis. And please consult with professionals, get legal help or professional human resources advice. Make sure your organization has insurance. In addition to the general liability insurance, you should also have directors and officers insurance and employment practices liability insurance. Now, I can guarantee that if you take these steps, you will be in good shape for avoiding the worst of these common employer pitfalls. And if we have the time, if there are any other questions, happy to take them.
Maria put a question in the chat. Is there any concern about this lawless government trying to get around how I-9 investigations are supposed to be done and trying to demand records directly from payroll platforms instead of from employers themselves?
Oh, Maria, I have a lot of concerns about what's going on right now. So yes, there are concerns, but for right now, all we can advise on is how employers should handle these things.
And Sheer asks, what were the insurances you recommended? It was directors and officers and
Employment liability insurance, employment practice liability insurance, EPL.
oh, Abby just asked, does EPL protect from treble damages?
It depends on the policy. So in a situation with wage and hour laws, typically they are not included. Wage and hour laws are typically excluded from insurance. So that would not be covered by your insurance. However, for right now, with paid family medical leave, that would be included. However, we have concerns that at some point, insurance companies may decide to treat them the same as wage and hour and not include them. So what I would recommend in that case is to speak to your insurance provider and make sure that your organization is that PFML is included and what exactly your deductibles are in that case.
Great. To echo everyone else, thank you. And thank you to everyone who attended. This was a lot of great information. And just to repeat, we will be sending out the slides and the recording. So just keep an eye out for that. And we'll have Liz's contact information. So yes, thank you all for a really great webinar. And thank you, Liz, for presenting this really important information to everyone.
Well, thank you, everyone. I hope this was helpful. And thank you, Claire and the Nonprofit Network. We love you guys.
Thank you. Have a great day, everyone.
Bye.
Bye.